Good morning, everybody. I am Jenny Beret with Sacramento Legal Documents, and this morning we are going to be talking about advanced dissolution with children. I have two different ways to do that. We're going to be going over marital settlement agreement, divorce with an agreement, and then a straight default agreement, but with children as well. So thank you all for being here today. I'm going to go ahead and grab our materials. And let me get this shared to the screen here. Okay, I wanted to start out with making sure that you guys were aware that there are some great call to intake forms on the website. Some of them are a little older. Some people like them done a different way. You can take the information and make your own, but if you don't have any set up yet, these are great to use. I used them for many years till I made some of my own. So the dissolution is actually quite extensive, several pages here. I did not fill that out. I just brought it here to make sure people are aware that you could get these, and you can use it for legal separation, annulment. Of course, dissolution is the main thing that we use. Talks about the custody issues, where the children have been the last 5 years. That's important. All of this is the UCCJA. And visitation. So I'm just going to scroll down here a little bit, talking about the different property. But this is very, it has everything that you're going to need to go over for the divorce, and then some, quite frankly. So, all right. So again, we're going to start with a dissolution with a settlement agreement. So of course you prepare your summons and petitions, respondent name goes there, petitioner's name there. Most of you have software which will input this information for you automatically. Scheduling this here in Sacramento. Standard restraining, family law restraining orders. Letting the parties know that they can't remove the minor children from the states and can't conceal property or transfer property or anything in that nature. Then we begin with our petition. Dissolution of marriage. We are married. Residence requirements. Either the petitioner or the respondent, it's in the or, has to have been a resident of the state for the least 6 months, and the county for at least 3 months. So you can, if there's only one of them, check mark one box. But if both of them meet those requirements, you can put both of them there. Statistical facts: the date of marriage, date of separation, and the time of their marriage. The minor children, and they're requesting a divorce based on irreconcilable differences. Of course, B or C if that's what you're dealing with. We don't do a lot of nullity. Can't even say it, let alone do it. Child custody and visitation. This is joint. Child support. This just lets them know that the courts can set support if there's no agreement. And we're going to be terminating the court's ability to award spousal support to both parties. Separate property, this is a little saying that I put on all petitions if they don't have anything specific. Now, if they specifically want to have their separate property confirmed, you of course are going to write that in here instead. Community and quasi-community, in this case, because we're doing an agreement, we just check marked B, because there is assets to be determined and divided, and we just put in discovery so we could get the petition rolling without having to take a lot of time to list all the property. No attorney's fees requested, and having your petitioner sign either just the first line or both lines. I actually have my petitioner sign the second line as representing themselves. This is our local form here in Sacramento. Make sure you're checking your county for any local forms. And because there's children, we have to fill out the UCCJEA. Declaration under Uniform Child Custody Jurisdiction and Enforcement Act. Of course, you're going to have your captioning here, have the court information here. And in this case, there's 2 minor children. You're just filling it out as it says here. You need the child's name, place of birth, date of birth, sex, period of residence. And you do need to show the period of residence for the last 5 years, as it says here. If the child, if there's more than 1 child and the residence information is the same, you can check mark these little boxes. If they're not the same, you need to not check mark that box and then of course list their information here. If they have more than 2 children, there's actually additional forms. There's additional residences you can list here just on an attachment, but then there's another form, an FL 105A. If there's additional children that need to be attached to that, you would check mark that box and you would attach the extra form. And it continues on the same way, filling out the child's name, information, birthday, and where they've been living. Next, they want to know if there's been any other court cases involving these children. So anywhere in California. So you're going to list those items here if there are any. If no, you check mark the box now. And does any other person claim to have any custodial rights or visitation with the children? Every once in a while, it could be a grandparent, could be a step-parent, could be a guardian, could be other things involved there. Very rarely does that come up though, in this case. Proof of service of summons. In this instance, we actually sent a mail and acknowledgement, a notice and acknowledgement of receipt. So this was the proof of service that I filled out. We're just going to check mark the boxes of the items that you're sending. They're always going to have check mark A. And also because there's children, we've got the UCCJEA that needs to be sent as well. Address of where the respondent served, and then the date and the city that it was mailed in. I'm the one who served the papers. Not a registered process server. Declare under penalty of perjury. And sign. And then this is the notice and acknowledgement of receipt. You're going to name the individual who's being served. Date of mailing should match your proof of service. This should also mirror your proof of service as well, what you're sending. So family law petition and the UCCJEA. So now that the other party's been served and has returned the notice and acknowledgement, my next step is I have them start their disclosures after service is complete. So in this case, we've got both parties, they're doing an agreement, so they're both involved, and I go ahead and I do the disclosures for both parties when they're working together. My pricing reflects that. Now, this is the one that you are not going to file with the court, and it reminds you of that right here. Do not file declarations of disclosure or financial attachments with the court. I tell people it's just kind of a cover page. So this is the petitioner's preliminary and final. We're attaching a copy of the 142 and the FL 150. An FL 155 is just as acceptable. I don't know why they don't list it on the form. They're usually good about that. You can also use an FL 160, which to list separate property or to list community property. When they are in agreement, I use an FL 142 to keep their main information and their current values and things like that, keep them out of the public record as much as possible. And you do not have to file the FL 142. I also think it gives them a little bit more space if they need to write anything here. So just kind of a sample. I'm not going to go through every single one of these. They had a house. I put a little bit about that they sold the house and split the profits evenly between them. Divided their household goods. Their vehicles here with a value. And their bank accounts each have their own. I find bank accounts are the least, the thing that people like to give the least amount of information about, but to drag it out of them. Retirement and pensions, CalPERS for both of them. They had some 401ks. And these are their debts. In this case, we just made a little notation that all the joint cards have been paid off, and each party retained any cards in their sole and separate property with that had their name on it. Now the financial statement, like I said, whenever possible, I do an FL 155, unless I feel that something's going to be in dispute. Then or they're going after spousal and things that have a little bit more different parameters to them, then I have them do the simplified form. But FL 150 is more robust, and if there's going to be a battle, anytime I'm doing like a request for order where you're going in and you're fighting for child support or spousal support, you want to do an FL 150 and provide all the additional information. So here you need to answer whether they're receiving SSI, TANF, or if they've applied for it, or if they're receiving it. It's not happening in this case. 2 children, 50-50 custody. Gave a little information about their custody schedule. This is the petitioner's income here, their salary and wages. They pay $685. He does for the portion of the daycare per month. He has some required pension and required health care costs, and again gives his mortgage or rent information down here. Employer information is filled in as it's asked for here. And then a value of the other party's gross income. If I have, like in this case, because they're working together, I do actually have her FL 150, 155, and so I fill it in from there. And then this is the form that we file with the courts to let them know that those disclosures have been exchanged. So again, this is the petitioner's preliminary and final declaration of disclosures. So he's the petitioner. The petitioner's preliminary declaration of disclosure and income and expense have been served on the other party by mail on this. Oh, that's it. Error I just saw there. That should actually be on date here on this line here. Looks like it got put up on there for some reason. And service of the petitioner's final declaration of disclosure and current income and expense are being waived. They're filing a form FL 144 at the same time that they're filing their declarations here. Okay, now the same thing with my petitioner here. Actually, as I said, I do the forms for the petitioner as well for the disclosures. Give them the little cover page, but I do change the captioning so that it does reflect the name of the respondent. Changing it here, respondent, and then, but again, preliminary and final. An FL 142 and an FL 150. A lot of times they'll give me tax returns as well. A lot of times I have this box check marked. If there's going to be a fight on spousal or child support, they need to have their tax returns. They need to do that as part of their disclosures. It's highly recommended. The FL 142, this looks just the same because these two were very much in agreement and basically did their disclosures together. So everything is the same on this. So I'm going to go through it rather quickly. And then we have the financial. Here we go. Again, the same, 2 kids, 50-50 custody. Her income is $58.24 salary. She also has to pay the 50% of the daycare, which is $685, and her rent is $1,600. This is her employer's information here. And again, we took this off of the other FL 55. She signs here. And then we also have the declaration for her as well. And the courts will not trigger a respondent's fee when you file the declaration regarding service of the declaration of disclosure and income and expense declaration. That has to be one of the longest form names ever. That and the financial income and expense, whether you use an FL-155 or an FL-150, that will not trigger the respondent's fee. So this again mirrors exactly what the petitioners did, except for we're check marking the box of the respondent. And we are waiving the second disclosure, so all of this is filled out as well. And here we go, down to that FL-144. So this is the stipulation and waiver of the final declaration of disclosure. Scroll down here and you can read the different information, what they are waiving basically. And under Family Code Section 2105D, the parties agreed to waive the requirements concerning the final declaration of disclosure. The parties agree as follows. They have complied with Family Code Section 2104 and did their preliminary declarations. They've been completed and exchanged. They completed and exchanged their FL-150s or 155s. They have a decent idea of what the earnings and expenses are of the other party. We have fully complied with 2102 and have fully augmented the preliminary declarations of disclosure, including disclosure of all material facts and information on the characterization of all assets and liabilities, the valuation of all assets that are community property or in which the community has an interest, and the amount of all community debts and obligations. Each of the parties enters into this waiver knowingly, intelligently, and voluntarily, and each party understands that this waiver does not limit the legal disclosure obligations of the party, but rather is a statement under penalty of perjury that those obligations have been fulfilled. The parties also understand that if they do not comply with these obligations, the court will set aside the judgment. So both parties actually sign this form. It gets filed with your judgment papers when you file that. Now, if for some reason the respondent actually filed a response, then you're going to need to include this appearance stipulation and waivers form as well, the FL-130. This is just showing the appearance by the respondent. So this actually could be filled in with either captioning of either party, because at this point the respondent has filed a response. They've paid that second filing fee, so it makes no difference who the captioning is at that point. And here you're going to choose A, B, or C. The appearance by a respondent by filing this form, I make a general appearance. B, I have previously made a general appearance. Or C, I am a member of the military service. I've applied and attached to this form the declaration and conditional waiver of rights under the Servicemen's Civil Relief Act of 2003. If someone is currently in the military, then you need to be very conscientious of this statement and make sure you're providing all the additional forms necessary for that. In this case, she had filed a response, so we just went ahead and said, I make a general appearance. I actually have this printout, and Jason, I just printed this up as a sample for you guys. Oh, it's both of them signed. The parties agree that this cause may be decided as an uncontested matter. Is that supposed to be the case? The parties waive their rights to notice of trial, statement of decision, a motion for new trial, and the right to appeal. The matter may be decided by a commissioner sitting as a temporary judge. The parties have a written agreement that will be submitted to the court or a stipulation for judgment. And none of these agreements or waivers will apply unless the court approves the stipulation for judgment or incorporates the written settlement agreement into the judgment. So I let people know, they're waiving all these different rights, but basically if the judge does not approve of their settlement agreement, none of this applies, and they go back to having, they could go to trial if need be, or whichever. But that if they did not file a response, then we're going to go to our next step of requesting an entry for default. If they did file a response, you are not going to include this form. Otherwise, all the rest of the forms are the same. So here Jason is entering in the request for default, the income and expense declaration and or financial statement, here they show both, is attached or is not attached, and a completed property declaration form, FL160, is attached or is not attached. But if you do not attach these, you must state one of the, you have to check at least one of the following boxes in order to not submit those. The first one being there have been no changes since the previous filing, and the issues subject to disposition by the court in this proceeding are subject to a written agreement. You can even check B if you have a written agreement between the parties. You don't have to check any of the other ones. And then whatever else is appropriate. There's no issues of child, spousal, or partner support. The petition does not request money, property costs, or attorney fees. There's no issues of division of community property, or this is an action to establish parental relationship. We do use these defaults for parental relationships as well. So your client's going to go ahead and sign there. You also need to include a self-addressed stamped envelope going to the respondent, and that is the address here. In most cases, you're going to be checkmarking 3B and including that envelope. Every once in a while, you're not going to have that in a case like this where you have a settlement agreement, but you may have received permission to do service by publication or posting, and you would checkmark 3A in that case. Again, the petitioner signs. Memorandum of cost, we're waiving cost and disbursements. If you have if they wanted to break it up, you could certainly put it here. If you have a settlement agreement such as we're doing, it would be lined out in the settlement agreement. If they even if they're splitting cost for my fees and things like that, I put it in the settlement agreement so that everybody's protected. We're going to date here again, and then declaring that the respondent is not in the military, active in the military at this time. They have to sign and declare that. Once the default has been approved by the court, these boxes are going to be checked. We're going to want to see the first two boxes checked. If the third box gets checked, that's no fun. That's going to come back to you. And they did not enter the default for some reason. Could have been a deficiency on your request to enter default on the form itself. It could be the respondent snuck in and filed an answer or response and you didn't know that. Whatever the reason is, they'll write it. The clerks will write it in for you. But hopefully you're successful with the checkmark that they mailed it to the respondent. The clerk will fill this in, and the default was entered in. Usually it's on the same day, and then the clerk will do their little stamps. All right, on to the judgment forms now. So first off, we want to fill out the FL-170, the Declaration for Default or Uncontested Dissolution. This is the form that keeps them out of court. As opposed to them coming to court and being sworn in, they fill this form out, and that way the judge can consider this their oral testimony. And in fact, that's what it says here under number 1. I declare that if I appeared in court and were sworn, I would testify to the truth of the facts in this declaration. I agree that my case will be proven by this declaration, that I will not appear in court unless I'm ordered to appear in court. All the information in the petition is true and correct. In this case, we are doing a default with agreement. You have to check, this is number 4, check A, B, or C. And if the respondent had filed a response, you're actually going to check mark box C, which is uncontested. Next area to go over is number 5, the declaration of disclosure. Both the petitioner and the respondent have filed or are filing concurrently a declaration regarding service of declaration of disclosure and income and expense declaration. That's the case in my case. As you saw, they both have those forms filled out. There are some different choices to make here if need be. The matter is proceeding by default, or this matter is proceeding as an uncontested case, uncontested action, and you would use that instead. These are also, you're going to line out what are some of the issues that are going to be addressed in the judgment. Child custody and visitation is definitely one of them, so I'm checking box 6. Information in the declaration under the UCCJEA Form FL 105 has not changed since it was last filed with the court. Actually hasn't changed since the petition was filed. If it has, you check mark that box and you attach an updated form. The facts in support of the requested judgment are, whenever I have an agreement, this is basically just what I put on each of these lines. Parties are in agreement. Please see marital settlement agreement attached to judgment. Same thing with child support. Now in the next example, we'll be going over default with a pure default with child support and such. So some of these boxes will change, and I'll go over that more with the next example. I request this order be based on the petitioner and respondent's earning ability, facts in support. In this case, parties in agreement. Please say marital settlement attachment agreement attached to judgment. Now, some counties require you to have a Dissomaster or Cal support printout attached to the judgment or attached to this. Sacramento does not require it. I think they like it, so I try to give it to them as often as possible, but sometimes when we're signing a settlement agreement, they agree to their own, even after I run calculations, it's nothing like what the calculations say. So I don't always, I don't want to make it confusing for the judge, so I don't put them in that example. But you will see in the next example where it's pure default, we do attach those. So make sure you just know what your county requires and attach those forms if necessary. I'm not receiving public assistance, and to the best of my knowledge, the other party is not receiving public assistance. Spousal support, they're terminating spousal support forever. I check mark it here, but we also have it covered in this, this settlement agreement, so I check mark that as well. Parentage action is not, we're not dealing with that, and attorney's fees are non-existent. And the respondent was requesting restoration of her former name, so that box is checked. And other parties are in agreement. See marital settlement agreement attached to judgment. I'm not going to sign there. All right, now we're on to the judgment. So in this case, we got the paperwork done prior to the 6-month statutory date. So we went ahead, we're doing the judgment for dissolution. And I have typed in here the date that the marital partnership will end. Proceeding was heard as default or uncontested and by declaration under Family Code Section 2336. This is the declaration, the FL-170 that we just went over. That's what that checkbox means. Keeps them out of court, so none of this is necessary. Court acquired jurisdiction of the respondent. On this day, they were served with process. And judgment of dissolution is entered. Marital or domestic partnership status is terminated, and the parties are restored to single person status on, and again, I type in this date. Now, if it was after the 6 months, you're going to leave both of these blank and let the court go ahead and put their stamp on it. The date that the judge signs it is the date that the settlement or date that the divorce is final. I only type it in when it's we're not close to the 6 months, and there's no way that I'm going to get it. You know, it's so soon that I know I'll even get it back, that the processing at my court won't take that long, so I fill it in. If I'm really close to the 6 months and then we go and file it, I'm going to leave that, I would leave that blank, because by the time that they process it and it goes through, it's most likely going to pass the 6-month deadline, so they'll put a stamp in there. Respondent's former name is restored to, as I said, she wanted her former name back. And then because this does have children in this case, we're going to attach the child support case registry form, the FL-191 and the FL-192, excuse me. The notice of rights and responsibilities is attached. The parties are required to fill out the FL-191 within 10 days of this judgment. And usually what I do is have the parties I give them this when they come in for signing of the judgment, and let them know to get that ready to go and filled out, because it'll it'll be needed 10 days after the date of judgment, and have them bring it back to me. Here we're putting the names of the children of the marriage and just outlining everything that's being covered in the judgment. Child custody is outlined in the settlement agreement. Child support in the settlement agreement. Spousal is in the settlement agreement. And we're terminating it. I put it both. You probably just put in the settlement agreement would be just fine. Property division in the settlement agreement, and then other is just any other, anything else that might be in there. I always have a lot of stuff in my settlement agreements. I usually write the number in of how many pages attached. I usually write that in before I file it. If you prefer, you can always type it in. Just make sure and wait until you have your notary pages. And sometimes the couples come in together, sometimes they come in separate. It can make a difference in how many pages you have attached. And make sure that you're including that FL 192, the Notice of Rights and Responsibilities. So, okay, so here's a sample. This is my basic marital settlement agreement that I use for everybody. It's quite lengthy. We start out first by going over the facts of the marriage. Husband's name, wife's name, parties were married on this day, how many children were from the marriage, and their names and birth dates. Date of separation, date that the petitioner filed a request for dissolution, and the date that the respondent was served with process. And then there's lots of legal jargon. I'm gonna go through these kind of quickly to show you, but you're more than welcome to reuse this sample as you see fit, add in paragraphs, or don't use it at all if you're happy with what you have and what you're using. So. All right, and arriving at this agreement, the parties represent they have an understanding and approximate net worth of each other. Intent and purpose of this agreement is to effect a substantially equal division between the parties. Goes on and goes on. Parties agree to waive Family Code Section 2105A concerning final declaration of disclosure, and will submit a fully executed stip and waiver. First things I start out with is custody and visitation. We do an introduction, and goes over, again, the mother and the father and the names of the children and their birth dates. And parties have met and agreed to the following parenting plan. A lot of these first few are just some basic things for the parents. Parents shall neither do nor say anything in the presence of the children that will diminish the love and affection the children have for the other parent. Goes on and on. Don't use your children as messengers or informers. A lot of this language is taken from what the mediators give and things like that. Parents may supplement or revise the terms and conditions of this custody agreement. Changes shall be in writing, dated by both the mother and the father and mother. And again, if controversy arises, the court, this lets them know they always have court and go back to court over anything. Legal custody rights and responsibilities. The parents shall have joint legal custody in this case. And then it just goes through to explain what is joint legal custody. Each parent shall be empowered to obtain emergency health care for the child. Parents shall consult and cooperate on any religious, educational programs. Parents shall select all schools, health care providers. This continues on, both may participate in school activities. Both are listed on the child's daycare and school emergency cards. Each parent is provided the other with address and telephone number within 2 days of any changes. Then we get down to the physical custody rights and responsibilities. These, in this case, my parents are sharing joint physical custody. Shall be shared by the parents in such a way as to assure the children have frequent and continuing contact with both parents, according to the following parenting plan. And then I go ahead and lay out the parenting plan. In this case, they had a 2255 custody schedule. Sometimes I'll have many paragraphs They go back and forth. I mean, I lay it out as explicit as possible so that they don't have any disputes. And then I have people on the other end of the spectrum who only want to say the children shall reside with each parent as at all times as mutually agreed upon, or the child shall visit with the father at all times as mutually agreed upon. So depends on your couple and what their needs are. I always let people know they should have a backup, that they can, of course, swap weekends or change days aside from this if everybody's in agreement, but that they should have a backup on their settlement agreement, but some people choose not to. In this case, they were very specific about their holidays, so we're going to go, I'm going to show you. We went through every single holiday here. Martin Luther King Day, President's Day. I mean, just holidays I didn't normally think about, but they outlined every single one of them. Children's birthdays, Easter Sunday, of course, Mother and Father's Day, Veterans Day. Didn't think of that as a holiday with children on normal, but you know, you get the day off. So they wanted to make sure that was written in there. Thanksgiving, Christmas, New Year's, and any other holidays not specifically mentioned shall be shared as mutually agreed upon. I have a paragraph here for the general rights and responsibilities. Each parent restrained from interfering with the rights of the children to transport belongings. Give 24 hours notice if you can't do your scheduled visitation, and so on and so forth. I'm not going to go through every single one of these. Protection of rights and responsibilities. Neither parent shall remove the children from the state of California, Sacramento County, or the immediate adjacent counties for the purpose of changing the children's residence without prior written notarized consent of both parties or until further order of the court. Parents to obey all vehicle laws. Failure to obey this order. Certified copy of this order may be filed with the Sheriff's Department. Just goes into, you know, if law enforcement has to get involved. Family Code Section 3048, that should be in all of your settlement agreements. I've had, when this started getting implemented, I definitely had judgments get kicked back because this language was not in my settlement agreement, so make sure it is. Then we go into child support. Petitioner husband shall pay to respondent wife as for child support for the party's minor children, Stella in the amount of $200 and Belina in the amount of $200 for a current total sum of $400 per month. So you know, usually the youngest child is more money, and it's a tiered plan. I think a lot of you know that. Usually when I'm dealing with the parents, though, they just have a set amount. And so I'll break it into two. I do explain that to them, but it kind of makes their eyes glaze over. I think it's more of an attorney thing to do that, or, you know, if the judge was to order it. So I usually just divide it in half if that seems appropriate for the parties, so that, you know, 200 can drop off once Feline, the older one's of age. Stella would be of age, and then they still have to pay for Belina, but only 200. So child support should be payable each and every month thereafter. Sometimes they decide to do child support broken into two payments, one on the 1st and one on the 15th, and I'll actually add that into the paragraph if that's the case. Parties acknowledge they're fully informed of their rights. The right to support has not been assigned to the Welfare Institutions Code, no public assistance application pending. Then I have a section regarding health insurance. Who's going to maintain the children on their health insurance? And so I list that first, but then if he's unable to, husband and wife share equally. Then a whole bunch of information regarding health, reimbursement for any out-of-pocket medical costs, the fact that they, you know, need to give each other notice as quickly as possible. Just lots of stuff here. Childcare expenses, each party shall pay 50% of all work-related childcare costs. I do sometimes change that. Sometimes people want to add in extracurricular activities as well. They agree to share that 50-50. Tax dependency. A lot of people don't think about this, but they really need to make sure they do, or else it ends up in a fight. Who's going to claim the children on their taxes? A lot of times it will go to if one party's If it's one-sided and the one party's paying a lot of child support, obviously, like if the father is, they usually want to claim the child. But whichever, it should still be lined out here, what they plan to do, and should be brought to their attention to talk about. Separate property and obligations. So now we're going to get down into assets. So for the purpose of this paragraph, it is just a lot of legal jargon explaining what separate property is. So I'm not going to go through all this. Community property and obligations. Again, this is just another section in regards to what is joint property, what is community property, and so on and so forth. Then we have the division of property and debts. So this is where I actually go through and divide up their property. Parties warrant and declare under penalty of perjury the assets and liabilities divided in this agreement constitute all of their community and quasi-community assets and liabilities. In the event the division is unequal, the parties knowingly and intelligently waive an equal division of the community property. So prior to signing of this agreement, in this case, the parties sold their community property, split the proceeds evenly. It's okay to memorialize that. I think it's good for the clients to memorialize what they did with their different property. And then wife hereby transfers and assigns to husband as his sole and separate property all right, title, and interest in the following community and jointly owned properties. So then I just go down the list. I've got the Honda Accord, all checkings and savings account, petitioner's name, personal effects of husband, employment benefits, retirement benefits, and husband to acquire the following debts, which I just basically put anything in his name. Now, these people, they kind of had it together. They had done a lot of their stuff prior to coming to me, so there wasn't a lot of stuff to report. If people are dividing up checkings and savings accounts, I will put like the last 4 digits of the account number. Same with credit cards. This is kind of a boring one because there's just not a lot of stuff that they divided, but it's okay to write that all out and you know, do the last 4 digits of any kind of account number so you're not putting so much information onto the public record. Husband hereby assigns, transfers and assigns to wife. Honda Pilot, checking and savings account, personal effects, employment benefits, and retirement benefits, and again, the thing about the debt. So parties request the court reserve jurisdiction. So this is just more about them reserving any rights. Neither party shall incur anything against the other party. Retirement benefits, both of them were waiving each other's retirement. So that's what this language is actually all about. I do put a little paragraph at the bottom that they carefully and thoughtfully bargained for this and they understand the termination waiver language contained herein. Do the same thing with spousal support when I'm terminating it. So this was a marriage under 10 years. If it was over 10 years, I would reserve it. Here in Sacramento, they prefer that when you have a marriage over 10 years. If they are absolutely adamant that they want it to be terminated, I would actually end up having them initial here under the termination information. I'd probably add another blurb in there that they have been told that they could seek advice from the attorney. I would just double do it so that the judge knew that we made it very clear to them that you know, they were terminating their spousal if it was over 10 years. Former name, I put that little blurb, I put that in there, that she's changing her former name back. Accounting is waived. The rest of this is a lot of legal boilerplate stuff. So accounting is waived. They're not requesting a formal accounting. Attorney fees and costs, there's none at this time, but if it was required, or if either party fails to perform his or her obligations under this agreement, and then attorney fees are incurred, of course, they can seek that from the other party. Reciprocal waiver of inheritance, so unless they are, they write a new will and put their ex-spouse on there, otherwise it's going to automatically be revoked. Voluntary agreement and advice to seek counsel of an attorney, so I have that in there so the courts know I told them I'm not an attorney and they should go see one. Execution of other documents. Throughout this agreement, representations have been made concerning completion of documents and instruments necessary. And so basically it's just stating that is, so if you need to do, if you need to execute other documents like an interspousal deed of things of that nature, that you're required to do that. Defaults are not waived. Effective reconciliation on this agreement. Captions are captions, they don't mean anything. Approval of agreements, basically it's just saying that even though the judge hasn't approved this yet, it's a solid agreement just with them signing it. Free from interference, that they're going to live apart and not interfere with each other. Miscellaneous provisions, service by mail, conformed, copy of the judgment is okay. This is provisions for appearance, stip, and waiver. It's basically the exact same language that is in that form FL 130. So I'm not going to reread all that. It's all the same there. And then I have a lot of just additional things here. Except as otherwise provided, this may not be modified by any more oral representations made by either party. I'll talk about jurisdiction. I don't want to go through all of it. If any portion of this agreement is held illegal, unenforceable, or void or invalid, the remaining terms continue in full force and effect. Just a lot of the same contract language you see in a lot of contracts, quite frankly. And then you go down and get their signatures here. They should be notarized. I always notarize mine. Notice of rights and responsibilities. Even though I have this information basically typed into my settlement agreement, I still attach it because the forms say to do that, and I don't want to get my forms kicked back. So, and then the notice of entry of judgment, which gets mailed to them from the courts. The date here of that the judgment was entered, judgment of dissolution. And again, in this case, because their 6 months wasn't up, I put the date here, otherwise you would leave that blank. Make sure you've got the addresses of the petitioner and respondent, and you need to attach 2 self-addressed stamped envelopes, one to the petitioner, one to the respondent. Make sure they're stamped. Now, I also wanted to give just a little example. I think it's actually something I'm thinking of going to, as instead of listing out all of their property right within the settlement agreement, you can attach exhibits. And so I gave some as a sample. This was one that was shared with me from another attorney, and I actually kind of like that because then you're not having to refix your margins and refix things over and over again, and when they change it up, you can just go into the exhibits and attach their community property. So I gave these as a sample, as well as as an example in case you wanted to use these. Community property awarded to wife, separate property confirmed to husband, separate property confirmed to wife, debts and obligations assigned to wife. I guess that was it. So, but if there's ones, of course, signed to the husband or things of that nature, then you'd want to put those in there too. So that is, in a nutshell. I'm going to stop sharing. So that's the settlement agreement default, or even uncontested. I did throw those forms in there as well. Next, we're going to talk about straight default with no agreement. So I will get those for us. Okay, so now we're ready to do a default, pure default with children. I'm going to pull this up and let me get my screen shared for you. All right, here we go. Now I will say that I had to pull different samples from a lot of different things, so the names might not match up on some of these, and we go from 2 children to 1 child, but you'll get the gist of it. But just so you know, I know not everything matches up perfectly. So summons as done before. Petition is going to pretty much be the same. There is one little difference here on page 3. Here we, did the date of marriage, statistical facts, the children. But one little difference is that now I'm going to go ahead and attach the property declaration to my petition, because in speaking with my client, he doesn't think that the respondent, she didn't really want to get divorced, and she's dealing with it, but is not very participatory, and probably won't be signing things or doing anything. So We're going to set it up right from the get-go to list all of the property that's involved, so that it's better when we get to the judgment and makes the court happier. So here's our FL-160 that we've attached. They've actually got very, very little assets. They did have some furnishings that were divided between the parties. Their vehicles here. She's actually got a little bit more expensive vehicle. They had a Fidelity account that had to be cashed out. And they have one small credit card that needed to be split between them. So I attached that to the declaration. So when she's served, she's going to see that right off the bat and has an understanding of how he's dividing up their assets and debts, in case she wants to file a response. Local form, make sure you check and make sure your local forms are filled out. Again, our UCC JEA with the children's information. Okay, so proof of service this time. We served it on her personal serve down here. As I said, she was not wanting to play, and so we did disclosures and everything and sent those all at the same time so that she had everything necessary in her original serve. So this is filled out. I just left my information here, but I don't normally do process serves. I only do service by mail. So this would normally be my process server filling this in. And they actually are usually registered, unless he had a family member or something do it. Then I help my clients fill out the form. I highlight the areas that the person who served the papers needs to fill out. These are his disclosures. These are also what we sent. Declaration of disclosure. I'll stop when we have a change. Otherwise, things are the same. This time, since we already did an FL-160 attached to the petition, of course, that's what I'm going to use as his disclosure. We're not going to just double do the paperwork there. We're going to use the FL-160. So that's his disclosure exchange. And then his income and expense. And I actually left this on the short form, but because this is a pure default, I may very well do an FL-150 if I think that it's going to be a pure default. And the declaration regarding service of disclosure. Now there is a little change here. He's filing his preliminary and final, but now the parties are not agreeing to file form FL-144. So he's coming down here and he's check marking AC. He wants to waive his final declaration of disclosure. And this is a default proceeding that does not include a stipulated judgment or settlement agreement. The petitioner waives final disclosure requirements under Family Code Section 2110. Now, when B would be checked is actually if a reply, this is the way it's been for me in Sacramento. If anybody has some different information, let me know. But say that both parties have responded, and then one of the parties is failing to do their disclosures, especially if it's the petitioner. I actually had that happen. And then there is a process that you have to go through with the court to waive their declarations. So now they've been served, we're ready to default. In this case, we're still not we're not attaching the forms because there's been no changes. If there is changes, of course, you attach the forms. And if there is changes and you're attaching these additional forms, make sure you have enough postage on your envelope to cover the additional forms, not just a 55-cent envelope. Okay, declaration for default. So it's almost the same, a little bit different. Here we're stating that this is a default without agreement. So the community, and then because of that, you have to come down and you have to pick A or B. There's no assets or debts to be disposed of by the court. That's the easiest. Or B, the community and quasi-community assets are listed on the completed current property declaration, which includes the total value of assets and debts that I propose to be distributed. The division in the proposed FL 180 is fair and equal division of property and debts. So we do attach that on here as well. Also, under the declaration of disclosure, you're going to change and you're going to pick B, that this matter is proceeding by default. I mean, petitioner in this action, and I've waived, and I filed a proof of service. I hereby waive receipt of the final declaration and disclosure from the respondent. Child custody and visitation. Now here I give a little bit more information because this is going to be a default. So you want to let the courts know what's going on. You can, if you can use attachment forms if you prefer, just check mark this box. If there's way more to put here, they're rotating every other week. So current custody schedule is 50-50, child rotates residence between mother and father every week. And facts in support of this judgment is father and mother share equally in child's caregiving. Or I could have even just cut and paste that exact same thing I just put up there. Child support, the information, first off, so you need to pick 1, 2, or 3. 1 doesn't apply in my case. It's not being enforced in another county. But the information in the child support calculation attached to the proposed judgment is correct based on my personal knowledge. And I request that this order be based on the petitioner and respondent's earning ability. Please see Cal support findings attached to judgment. So we do attach those in this case. I'm not receiving public assistance, and the other party is not receiving public assistance either. Knowingly asked to terminate spousal. And they would again come down here and sign. But you see, I do have another copy of the FL 160 attached again to this FL 170, so that they, it may be overly redundant. You may not have to attach it. It does say attached to the judgment, but we've done it once. It's really easy to put another copy attached here and just make sure the judge is getting all the information necessary. I do include this page 4 because it says page 4 of 4. So for the court to get a form that only has pages, 1 to 3, up to 3 of 4, then they question that and they kick it back. So even though it's just kind of a redundant instruction page, I keep that as part of my FL 160. Okay, then the judgment. So a few changes on the judgment as we go through. Again, this is going to be done though by default or uncontested by declaration. That part is all the same. Respondent was served with process, it's all the same. In this case, it's been over 6 months, so I left it blank. So that when the judge signs the order, then that's when they'll put these dates in here as well. Children are involved, check mark that box. Children of the marriage, here I just made it 1 child. And then child custody is going to be requested as in the attached FL 341. Child support based on the FL 342. Here on the spousal, since we're just terminating it, I just check mark the boxes here. If you were going to actually get spousal support, you would want to attach the form. And then property division, and I put that under other community property declaration FL 160. Okay, so first attachment, this is the FL 341. Yes. Attached to the judgment, here we go, judgment form FL 180. And you're just going to go through and check mark the boxes that are correct. You're basically stating that this court has jurisdiction to make these orders. The responding party was given notice and opportunity to be heard. The country of habitual residence is the United States. And it does let them know what the penalties for violating this order is. Child custody of the minor children with their names, birth dates. Need to put the legal custody, who that's going to and the physical custody. In both cases, as I said, they're sharing 50-50. Child abduction prevention is not a factor in this one, but if it is, you would check mark that box and you would need to fill out this form and attach it as well. Visitation, reasonable right of visitation to the party without physical custody. Taking note that that is not acceptable if this is a domestic violence case. You would have certainly lots of different changes. Here, see the attached how many page document. So if they had just written up their own little agreement or something, you could attach that, incorporate it, and now it's incorporated into the judgment and made a part of it and made an order. Parties will go to child mediation. That's, of course, if there's a dispute going on. No visitation. That's appropriate if there's domestic violence. Visitation, you know, and I didn't check mark that box, and I probably should have. Visitation, this E should have been check marked. My mistake there. Oops, sorry about that. And then because they're sharing custody, you could even put, you can leave it blank, or you could put petitioner and respondent. But I actually went down here to section 4 and put other visitation. Father shall have child for 1 week, 8 p.m. from 8 p.m. on Sunday to 8 p.m. on Sunday. And the mother shall have the child for 1 week from 8 p.m. on Sunday till 8 p.m. on Sunday. And each parent shall rotate every week thereafter. If supervised visitation is in play, you're going to check mark this box and write out here and make sure you have this attachment. Transportation to the visits will be done by the petitioner. Transportation from the visits will be done by the respondent. And travel with the children, I put this on pretty much every order. They must have written permission if they're taking them out of the state of California. You can also do the following counties and list the counties or any other place that they feel is necessary. Holiday schedule, I've attached a holiday schedule, or you could type it in here below. Additional custody provisions, I've attached the form. Joint legal custody, I've attached the form. Access to the children's records, just a standard thing. Now that has become a court order. So this is the children's holiday schedule attachment. We're attaching that to the findings and order after hearing or judgment. Sorry, my mouse decided it doesn't want to work. There we go. All right. So now I didn't fill this all in for purposes of some time that I had going on here, but wanted to give you kind of a sample. You can put this time in here, and this will always be the start and end times of visitation unless you specify otherwise, like I did here with Labor Day. Every year is so like on Mother's Day, where the mother gets them every year, Mother's Day. You might put mother here. You can also put petitioner respondent. I've seen it done both ways. Usually when the parties fill it out, they put mother, father, so that's what I do. But petitioner respondent is fine. Or if they if they're going to rotate even and odd years, you put it here. I actually fill it in on both sides. So if mother's got even, I do father odd. You could just list mother and not put that. But I like to fill it in for them. And you can go down here. There's a lot you can go through down here. If 3-day weekends, what would you normally do with that weekend? Vacations. So here he can take a vacation with a child up to 14 days, 2 times a year. The other party has 7 days to respond to that if there's a problem with the vacation schedule. If the parties cannot agree on vacation plans, so I have a little backup here. If they can't agree on it, then the petitioner, in the even number years, the parties will follow the suggestions of the petitioner, and the odd number years, they'll follow the respondent suggestions. Vacation may be outside of California, and any vacation outside of the United States requires written consent. Joint legal custody, these two are sharing joint legal. So we went ahead and attached this mouse, FL 341E. And again, you're attaching this to the judgment. Parties, petitioner, and respondent will have joint legal custody of the children. They must consent in decisions in the following matters: enrollment into a school, beginning of any kind of mental health counseling, extracurricular activities, selections of health professionals, participation in religious activities, and out-of-country or out-of-state travel. And there's things here to write in if other consequences if they don't abide by the granted orders. This is special decision-making designation. Healthcare notification. Each party must notify the other of each health practitioner who examines or treats the child within 3 days. Just as a standard would be a standard, not an emergency. And each party is authorized to take any actions necessary to protect the health and welfare of the children, including emergency procedures or treatment. And the parties are required to administer prescribed medicine for the children. School notification, name. Parties will not change the last name of the children. Additional provisions for physical custody. This again attached to the judgment. So there's so many things that they can go through here and really line things out. Notification of the party's current address. So this states that within 5 days, they have to let them know if there's a change in their address of their residence or email. Telephone number, if their cell phone number changed. Notification of proposed move of a child. I left that blank because they have to get permission if they're going to move the children, not just give notice. Child care, the child must not be left alone without age-appropriate supervision. Right, a first option of child care. So if the child's going to be left home alone for more than 4 hours, then the other parent gets the right to spend that time with the child instead. So they're the provider, the child care provider. You can even get into canceled visitation time and what to do with that. Phone contact between parties and children. Children may have telephone access, and the parties may have telephone access to the children at reasonable times for reasonable durations. Also, the custodial parent can make the child available. I actually use that quite a bit for people, not in this case, but no party or any third party may listen to, monitor, or interfere with the calls. No negative comments. Discussion of court proceedings with children. Just seems like you shouldn't have to put that on a judgment, huh? But you do. No use of children as messengers. Alcohol or substance abuse. This is usually a big thing and usually checkmarked by the parents. No exposure to cigarette smoke or marijuana smoke in general. I would assume that includes vaping these days as well. No interference with schedule of any party without the party's consent. So whenever it's the other parent's parenting time, they can't just go and schedule extracurricular activities or a birthday party. They have to call and get permission and work it out with the other parent. Third party contact, if that's applicable. Children's clothing belongings, each party will maintain the clothing. And terms and conditions of this order may be changed, and just talks about if they want to change the order, they can. They just have to do it in writing to each other. All right, child support information. So this is attached to the judgment, FL 180, a printout of the calculations and findings incorporated into this. Income. So here I wrote out the parties' income. Children of this relationship, there's 2. It's being split 50-50. And the court orders, child support, beginning 10/1/20. Oh my goodness, I forgot to fill this out. So the child's name, date of birth, and see, as you can see, this actually is one child. I just went back and forth just getting this one. I don't use this one very often. The monthly amount should have been here. I do have it down at the calculation, and I'll show you that. Payable to, make sure that is filled out. That is absolutely an error on my part. Payable on the 1st of the month, or whatever is applicable. Mandatory additional child support. Petitioner must pay both parties pay 50% of any child care related costs. He wasn't sure what they were at this time, so these were left blank on purpose, but that they all would share 50%. Then comes down here, the total child support per month is $177. So if they knew what the child care cost, you put it in here. Or if they knew what the health care cost, you put it in here, and have them add that up. Healthcare expenses are being covered. Healthcare coverage is being given by the petitioner or plaintiff. You want to, by the petitioner, you want to make sure this is filled out. Health insurance is not available at a reasonable cost at this time. Looks like I checked mark the 2 boxes. So you're going to fill out A, B, or C, whichever is appropriate. In this case, because petitioner is supplying it, really B was not appropriate, or B is appropriate. And then they'll have to have them on Medi-Cal, I would assume. Employment search order, if that was necessary. Again, notice of rights and responsibilities. Child support case registry form lets them know they need to fill that out within 10 days. And so here I've attached the guidelines for the support. That's where I got that 177 figure from. One child, 50% of the time. So we do attach that as well. And that all gets merged in and made part of the judgment. And then, of course, the notice of rights and responsibilities. And this is the FL 160 that we stated was going to be the division of their assets. So that's attached at on the last. I would actually attach an endorsed one that I'd already filed from the court earlier when he did his declaration exchange, and I would attach the endorsed copy, not just a whole nother one that would confuse them. All the way down, and that's the end of their judgment. Oh, and then there would be a notice of entry of judgment. I did not attach that on here, so let me stop sharing. All right, so that is the default, pure default with children. I want to leave some time for any questions that you've had either on the pure default with the children or the marital settlement agreement default. So we'll take some time for questions now.
But the notice and acknowledgement of receipt is not necessary if you file a POS, right?
Yes, that's correct. And Mira and I are trying to grant for her, but yes, the notice and acknowledgement is only if the respondent is willing to sign and not have someone come to the door to serve them. Otherwise, we will just file the
Okay. Next question is, when filing the divorce petition, how do you ask the court to have a respondent take over completely a vehicle under petitioner's name and driven by respondent? Respondent is paying, but petitioner fears he will purposely stop paying to hurt her credit.
So you can do requests for orders. Obviously, we didn't get into that in here. That should be a whole nother class, quite frankly, doing different requests for orders. But you can lay that all out in the petition. You want to make sure it's in the petition. You could do it by attaching the FL 160. You could put it in that box or have a separate attachment when it talks about separation of property on page 3. But so if you're unsure for any reason, if the respondent's going to respond, be as detailed as possible in the petition. Provide any additional attachments, even if you're going to be redundant and reattaching them to judgments and stuff. That way the court knows that the respondent has received, notice that this is what the intention is. The intention is that the vehicle is under the petitioner's name, going to be driven by respondent. Yeah, so I mean, you would lay all that out and basically lay it out in that language that the respondent is going to maintain the payments on the vehicle, blah, 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 and hold liable. I mean, I can give you some language if you need specific language. You can always reach out to me via email and I can give you some specific language for that. But you list it all in the petition so that when you get to the judgment, you're basically restating the same thing. And if the respondent doesn't respond and say no, then the court feels, they're going to make those orders for you. They've been given their chance to respond.
Okay. Question is, can you please share your MSA in Word format so we can edit?
Yes, there were several people who were asking for that. So I will make sure, maybe I can have Tracy send it out to everyone who took the class. I'd be happy to give it to you guys in Word format, no problem.
Okay. The calculated, whoop, jump down.
The calculated printout on support. Yes, you have to have either Cal Support or DissoMaster so that you can print that out. I guess, you know, there is a free calculator online through Child Support Services. I haven't ever used that though. I at least get Cal Support. I use Cal Support. So I'd recommend that to everybody. It's great for doing calculations. It's great for doing calculations.
Okay. Catherine asks, you did stipulation and waiver of DOD, but you waived it on the declaration of DOD. Why do you need both?
Well, who did a step in waiver? They on the declaration regarding service of disclosures, you'll see you specifically have to, if you're waiving that second, that's when both parties are, first off, that's when both parties are participating, whether it's by a default with agreement or it's uncontested because the respondents filed an answer. That's when you file that FL 144. And if you look at the declaration, you know, it specifically asks that if you're filing 144. So I do file both of those. I file the 141 and the 144. And even if it's a bit redundant, my court will kick it back if the 144 is not in there.
Okay. Thank you. Myrna asks, so what triggers the respondent's fee? I once filed a respondent stipulation accepting the court's jurisdiction, lived out of the country when served, and was surprised to have the court request a fee. Of course, a fee waiver was filed and approved, but that was an unforeseen delay.
Gotcha.
So I guess what triggers the fee?
So the respondents, yeah, it's going to file, it's going to trigger a respondent's fee. So the FL 130, you do not file that unless there has been a response. I do not file those on my default with agreement. Only the FL 144 where they're waiving the second set of disclosures. But if you were to file that FL 130 and the respondent hadn't filed an answer, that will trigger a respondent's fee right there. The things that the court takes, they will take the FL 150 or 155. They'll take the FL 141, the declaration of disclosure, and that does not trigger a respondent fee. And then also, if they have their signature on the FL 144, that kind of goes along with the 141, and that will not trigger a respondent's fee. Nor will it trigger a respondent's fee on the settlement agreement itself. But that is basically the only documents that the respondent can sign and file with the court.
Okay. Myrna asks, no attachments if you are petitioning for physical and legal custody or joint custody? And then when should we use FL 144?
Use the FL 144 when the parties are in agreement, either by doing a default with agreement or it's uncontested because the respondent has filed an answer. You can put attachments for physical and legal custody on attached to the petition. If you think it's going to go into a straight default, put as much as you want attached to the original petition. It's not going to hurt. You just want to make sure that what you're asking for in the original petition is what you're asking for when you get to the judgment. Otherwise, it's going to trigger hearings or you need to do a request for order at that point.
Okay. Let's see. It looks like Lori was pointing out that their FL 170 was revised in January.
Oh, yeah. I saw that too, Lori. Thank you. On my first, the one with the settlement agreement had the updated form on it. And this one, when I printed it, must have been an older one. So I apologize. It has been updated. Use the one under, I did use that on the agreement one.
And then this looks like it was already answered, but it was asked, child support requests only become effective when judgment is ordered. What do you need for immediate orders?
You have to file a request for order. If you need something immediate, you have to file a request for order. Otherwise, it'll wait till the judgment's entered.
Uh, Charlotte asks, what if the defaulting payee refuses to sign FL 191?
That's fine. Have your petitioner file the 191. There's many times that neither party sends those in. I mean, it's if it ends up going to child support services or enforcement, they're gonna get that information and find out. So if the respondent doesn't fill it out and doesn't send it in, they don't. Nobody's gonna come after or kick it back because of that. It happens.
Okay. Charlotte asks, if there was a previous child support order done through DCSS, are there any forms to complete or steps to do? I'm going to guess that this is probably connected to the previous request.
Yeah, but that's a really good question because none of my samples really showed that. You would basically fill that in under the child support section. And if you have a copy of the previous child support order, you want to attach that. And you can just say that support has been assigned through child support services. If there's a different case number, if there's a family services case number, you could, show that. Or if there's already been a hearing on it, again, attach the order to it. So that's what you would do in that instance.
Okay. Lori asks, when using 341, etc. forms, do these need to be prepared prior to filing petition?
They don't have to, but like I said, if you think you're going into a pure default, the more notice you give the respondent, the happier it's going to make the judge, because so if you know it's a pure default, especially if it's complicated, my example was 50-50 custody, but especially if you're not giving visitation to the other party, yeah, do the forms ahead of time, attach them to the petition, and that way they're served with them, and that way if they don't agree with that, they have their chance to respond.
Loretta asks, when preparing an MSA, does respondent have to fill out the form mentioned? Do they have to serve the petitioner and fill out a POS for the court and file to the court?
Well, when you're doing a settlement agreement, the respondent is obviously involved because they're going to be signing for it. And I don't know if I mentioned, but you definitely want to notarize all your MSAs. So I'm not sure exactly what form do they have to serve the petitioner and fill out. You do still have to do service, even if the respondent is signing the MSA and is involved. Either doing service by having them served on the person. That's why I do a lot of notice and acknowledgements, because I have parties that are doing this together. So I just mail the copies to the respondent, have them sign it. But there always has to be a proof of service. That's what starts all of your statutory timetables ticking. The 30 days for the default, for the response, and then, of course, the 6-month time period. That goes from the date on the proof of service.
Marcel says, thank you, Jenny, in all caps, very happy. Laura says, thank you. Alvin is asking, when is the time both parties need to file the FL 141?
So technically the law says that disclosures are supposed to be done 60 days. So like the petitioner is supposed to get their disclosures done 60 days after filing the petition. The respondent is supposed to get theirs done 60 days after they are served or file a response. So, but the courts are very lenient on that. I technically don't file my FL 141s until I'm filing the judgment and everything else. But of course, if you had someone who became uncontested, or became contested, you'd want to get all that in before going to hearing and going to trial setting conferences and things like that. So it just depends on whether they're in agreement or not, but you can file it anytime. It really doesn't make a difference.
It's not gonna blow it up.
Yeah.
That's always a good one. Maria's asking, when Department of Child Support Services is involved, they have to sign off on a judgment. Is there a way around this? She says you had a default judgment kickback because there was no signature from DCSS.
Yes, I didn't even, yeah, if, I guess it would have to depend on the court, because I actually had mine approved showing just a copy of the order from DCSS. But again, that was already an order in place. If you're having them, if they've been if there's no actual order already going for child support services, then they are going to have to sign off on it. You could put just a place for them on the settlement agreement or stipulation. I'd have to think of the best way to do that as a default. I had a sample of that back once in Fresno, and I haven't had to use that up here. But DCS says, and you would want to serve them and everything and make them aware of it. So that's when we could actually even do a whole quick little session about when child support services is involved, because they've got to be given notice of everything.
I look forward to that, and I'm going to pre-register for that right now as soon as we come up with a webinar for that. Okay. Question is, how does child support software differ from, I'm going to guess they're going to ask from like the child support calculator available online. Is the guideline calculator online admissible as attachment to judgments?
I'm sure that it is. I haven't ever used it because I use my Cal support, but I'm sure that people, who don't even use LDAs can print that. The calculator it's just as good, but I do believe that Cal support and child support and DissoMaster is way more detailed. You can get in, if you've just got straight people making wages, and kind of lower wages and stuff, it's going to be no problem just using it on the computer. And if that's all you had, I would attach it and make sure the judge accepts it. I've never done it. I've always used Cal support. So, but it is the same calculations that are used. It's just not as robust. You can't change tiny little things and don't have as many choices.
So you're saying if there's multiple revenue streams that they have as income, it's best to use the child support? Or
yes, and especially if there's like bonus involved, where they set a percentage of the bonus over a certain amount of years, and the attorneys get really deep and in depth when it comes to setting support and can really tear it apart. So just depending on your clients. And the nice thing about getting Cal support is you can save it. You create a file for every single person, so you can go back in later and make adjustments. You're not having to re-enter all the information in and things like that. So you're also, creating a separate file for each of your clients and customers.
Tina says, thank you, Jenny. And Maria and Lori are both asking for the language that DCSS would use for them to sign off, if you have that.
Okay, I'm making a note on that. I'm going to send this stuff over to Tracy by tomorrow, the MSA and sample and stuff, so she can get it out to everybody. But I will definitely get that too. And I want to thank everybody too for joining in. I appreciate it.
Thank you, everybody. And if you have any further questions, you can reach out to Jenny. She's always happy to answer questions. I see her in the forum all the time answering questions, and appreciate it very much. And everybody, thank you, and have a wonderful afternoon.
All right. Thank you all. See you soon.
Thanks,
see you in the lounge.